good afternoon, and this is Katie Yelton and Jim Platt and Briar Andreessen, and we are going to spend the next hour or so talking to you about various electronic health records issues that may be keeping you up at night, should keep you up at night, and hopefully offer at least some practical tips on how to think about these things. A few housekeeping items. Our March webinar will be on March 11th for the second Wednesday of the month always. And David Glazer and Steve Beck, and maybe some others, depending on who we can rope in, are going to be talking about what hospitals and clinics need to understand about ancillaries. So they're going to be answering some of those straightforward questions you might have about, can we accept outside referrals on our MRI? And what the heck is the difference between provider-based and under arrangements? And just sort of identifying the legal pitfalls with imaging, PT lab, and other ancillaries and joint ventures surrounding those things. So that should be super interesting and informative, and that's next month, March 11th. We always want to hear your ideas about suggestions for topics, what you like, what you hate that we've done, and so that's always helpful. And you can also, just a reminder, you can access these presentations on our SlideShare site. It's free. You can forward to a friend. You can listen over and over. Use it to put you to sleep at night, however you want to do that. So, without further ado, we're going to be doing sort of a grab bag approach. We thought, gosh, we get a lot of what are seemingly sort of random questions about electronic health records. We want to touch on some of those. Hopefully they'll be insightful. We're going to bounce around between the three of us. And if you have questions that you would like us to address, we'll try to save some time at the end for those. Please ask them during the presentation or send them in. It's, I think, on the bottom right-hand corner of your screen. You can type it in, and then we'll try to take a look at those as the other folks are talking so that we can address them. All right, so I guess in no particular order, the first topic we want to touch on is electronic health records and surveys. So I know that hospitals and clinics aren't necessarily surveyed, at least not as often as hospitals, and nursing homes are often surveyed more than hospitals. But I know that many of you hospitals out there have attached nursing homes, and as EHRs become more prevalent, surveyors get to be working with these on the surveys, and you might want to know what the heck you're supposed to do and what sort of pitfalls there are. So the first thing I would suggest is taking a look at CMS's 2009 memo. Props to them for being kind of ahead of the game, talking about this in 2009. That's really addressed to the state survey agencies who survey hospitals and nursing homes. And it's supposed to tell the surveyors how to deal with electronic health records during surveys. And it's actually, it's only a couple pages, it's worth a good read. If you're not surveyed by a state agency, if you have an accrediting body survey, it's worth taking a look at that guidance to see if they say anything about how surveyors are supposed to access and use EHR during surveys. So let's take a look at some of the CMS language. So CMS says that a provider must grant access to any medical record, obviously during a survey, including access to EHR, and when that's requested by the surveyor. And if it is requested by the surveyor, the expectation is that the facility will do a couple things. They will provide the surveyor with a tutorial on how to use its electronic system. They will designate an individual at the facility who will access the EHR and respond to any questions the surveyor might have. And I think, it seems like sort of a lot to ask of a facility, but we'll talk about why you want someone to be sort of holding the surveyor's hand when dealing with the EHR. And the memo contemplates that you're going to give the surveyor direct print capabilities. So you're going to be able to print stuff from your EHR, and if you aren't able to do that, then you have to be able to provide them with a printout of any record that they might ask for. CMS expects you to try to provide the records in a read-only format, which is a good tip, because we don't want surveyors to be able to change or inadvertently alter the record. And if the surveyor is not able to print, you need to be following up with them. The surveyor isn't supposed to be making unreasonable requests or trying to print the entire record. They're supposed to kind of keep those requests reasonable and only print what they need to support their findings. So a couple issues that come up in this context. The first question to think about when you're preparing for a survey and you have an EHR is, what does our EHR include? What is the surveyor going to be able to see? It depends on the setting you're in, but particularly in the long-term care setting, the EHR might not include all of the records that are, I guess, applicable to the care of patients. So, for example, I'm thinking about like a nursing home. The staff may have a neurocheck sheet that they keep that's on paper and that isn't part of the EHR. Well, that might be relevant to a surveyor's questions and findings and review, but it isn't necessarily in the electronic health record, and so you don't want them to think that that sort of document doesn't exist. So what we'd suggest is, and I think what the CMS memo is advising you to do, is at the beginning of your survey, at the entrance conference, if they're going to be using the EHR, is to sit down and say to the surveyor, this is what our EHR includes, or maybe even more importantly, this is what isn't in the EHR but you might want to know about, and really try to lay out the roadmap of what they can expect to find. Another issue that comes up with this is the use of shortcuts or cheat sheets that staff may have, maybe because they sort of hate the way the EHR works in a particular functionality. So maybe the electronic medication administration record is just a bear to use, and so the staff and the physicians, they keep track of medication administration or whatnot on paper. Well, again, that's something that's not going to be captured in the electronic record. You want to make sure that you're providing all the relevant documents so that the EHR doesn't reflect an inaccurate, I guess, picture of the care or treatment. On the printing issue, I probably don't need to tell you that printed records from the EHR, I think most often look totally different than what you see on the screen. And so the surveyor may see what they need to see to answer their question, and then they might say, I want to take a copy of this with me, and they try to print it. And instead of printing the nice, snapshot of one day for a patient or something, they print and first all of the treatment notes come out, then all the progress notes come out, then all the medications come out in one chunk, and then all the lab results come out. And you have this giant stack of paper that isn't coordinated in any sort of meaningful fashion. So know ahead of time what your printed version is going to look like. And actually, I know of one client that has a little, I guess, guide to the printed version of the EHR that says this is what's included in the EHR, and this is the order that it's printed, and they try to just make whoever is requesting the record and they're giving it to aware of how it's printed and how that's different than the live view. So just something to think about. Always keep a copy of your printed records that you give to the surveyor, because that's how you're going to be able to track back as to what they've taken back to their desk so that you can see what they're looking at. Always try to keep out any sort of internal risk management documents out of view of what a surveyor might see on the EHR. And be aware of what your little tricks and internal notes look like on the EHR. It might be that your staff has agreed that they're going to use this particular symbol that's like a red exclamation point, and that's just what everyone knows. You need to, and that's there. Somebody needs to do something, but you don't mark that it's been done, or you mark that it has been attended to, and the surveyor sees it and they think there's this huge red flag that everyone's ignored. So that is another thing to think about. So just want to touch briefly on what a surveyor might do in terms of viewing the EHR and thinking about privacy and security implications. So you're probably thinking, what do you mean? I thought we were talking about licensing and accrediting surveys, not Office of Civil Rights audits. Well, it turns out that in that memo from CMS to the state agencies, there is a direction and I guess a contemplation that surveyors will be looking at how the EHR system is being used and whether that's consistent with the Medicare conditions of participation, which, at least for hospitals, have mention the keeping confidential patient records. And so even though the surveyor isn't doing a HIPAA audit, they're certainly going to be trying to see if confidentiality is preserved. And so the things they're going to be asking about are sort of the same types of things that one might look at in HIPAA audit. Are your computer screens left showing information when people have, moved to another part of the room? Are you posting passwords? Sort of these obvious things. Have you shared passwords? The things that are going to implicate HIPAA in the EHR context could certainly come up in a licensing or accreditation survey. And the state survey agency or the surveyors are directed to refer any sort of privacy issues to the CMS Office of eHealth Standards and Services or the Office of Civil Rights. Apparently that CMS office is the office within CMS that worries about privacy and security. So just know that these agencies talk amongst themselves, and just because you think you're not having a HIPAA audit doesn't necessarily mean that a really bad, blatant practice can't result in trouble later. Okay, so I'm just going to touch briefly on this interoperability issue, and the main reason I bring it up is because I think just last week the Office of the National Coordinator for Health IT released a report, and it was picked up as sort of breaking news by Modern Healthcare and other trade groups, as there being now a deadline for 2017 of 2017 for everyone to have EHR that's interoperable. So this is not a deadline for interoperability where you have to do something for payment purposes. This is not like a meaningful use deadline. It's really sort of an aspirational goal, I think, by the Office of National Coordinator for Health IT that basically says a bunch of stakeholders in the public and private sector should be working toward these various measures in order to make sure we have an interoperable, I guess, health IT landscape. So right now, I mean, I wouldn't even read the report. It's a little bit of mumbo jumbo at least, and it's aspirational. So I guess don't freak out about the 2017 deadline at this point. It is really just about how the industry is supposed to be working towards interoperability.
So Katie and I wanted to talk for a second about an issue that we've seen a few times come up involving meaningful use payments. And this involves the following situation. So your particular clinic or hospital or health system is employing a physician. It's in the middle of the year. That physician was previously employed by another clinic or hospital or health system. And while he was at Clinic A, he signed an employment agreement with Clinic A that assigns the right to meaningful use payments to Clinic A. Now he's coming over to Clinic B, and he signs an employment agreement with Clinic B, assigning to Clinic B the meaningful use payments. So who gets them? How's that allocated? We've heard of situations where the two clinics get together and say, well, let's kind of cooperate on this together and split it in some fashion. And then, of course, we as lawyers get the question, are there any laws about this? Is there any particular regulation about how we go about sharing these payments? And thus the reason for this slide.
So the regulations on this are not particularly helpful. They at least say that each eligible professional may reassign their incentive payment, the entire incentive payment, to only one entity. So that's at least clear, but it's not particularly helpful in figuring out this problem. And so I guess the first question is, how do you make that reassignment effective? Most employment agreements with physicians and other practitioners say the reassignment that the practitioner will reassign all of their, I guess all of their revenues for their professional services to the employer. We think that should cover it, but maybe you want to throw in more specific language to capture any sort of incentive programs. And very unhelpfully, CMS has basically said the assignment process, it's a contract issue. You need to try to figure it out on your own. And we don't really have anything much to say about when there are multiple entities. I've looked at the FAQs on this on the CMS website, and people are trying to ask about what you do for multiple entities, and CMS has sort of dodged the question and instead just talked about multiple locations with EHRs, but that doesn't really answer the reassignment to multiple entities question. So as Jim noted, there are a couple different situations. The practitioner is splitting a reporting year where they're at one place and then they go to a second place. From what I know about the registration process, it would make sense that the first practice would register the eligible professional, and they would include in their registration that the eligible professional assigns the payment to that practice. So I think if they move, the second practice is able to do something that switches that within the system or works out with the first practice how you'll divvy up the payment. Whatever payment that is reported will be going to the first practice. And again, if you're able to report because you've combined the information from the two places, that's another thing that has to happen. You have to be able to, in order to report, you have to be able to say throughout the reporting period what the eligible professional did, and you're probably going to need data from the multiple locations. So this is definitely a coordination effort. It's not one that CMS has weighed in on. So that's the issue. I guess the other issue to point out is that an eligible professional obviously may leave the practice after they've been there for the entire reporting year. The practice reports, and then the eligible professional gets audited, and so they've left, but they don't have any information about what was reported because they left and they didn't take it with them. The regulations say that the eligible professionals are supposed to maintain documentation of, supporting meaningful use for at least 6 years. So that's more of a problem for the eligible professional. However, when we've seen audits come, they're often directed at the entity that's reported, and so they'll probably have information. I guess the takeaway from this is that if you're sharing information, the entity that's reporting wants to be able to have all of that data from the multiple locations in order to support them in an audit.
Another question that I've asked about organizations that move money back and forth to share payments that one received is, does Stark apply to this? It seems like it would if there's a group that's owned by a bunch of physicians and those physicians send referrals to the hospital, and the hospital and the physician group are allocating a meaningful use payment that the physician group received. Seems like Stark would apply to those payments, and so if so, what exception under Stark would cover the movement or shared payment from one health system to the other? Maybe it falls under fair market value because there's being some service rendered in the exchange of the information. Maybe that works. Maybe the isolated transaction exception works. But I don't think anyone's given a lot of thought or attention yet to the movement of the money and how to properly document that and how to properly analyze that under some of these laws. So this is Jim Platt. If you haven't already figured out who I am, I'm going to talk a bit about EHRs and malpractice, and then a bit about EHRs and medical scribes. First of all, with regard to EHRs and malpractice, this is certainly all a very new and emerging area as far as malpractice law is concerned. You always appreciate the fact that law is soaked in history and prior precedent and how things used to be done in the old days with paper records. So as we go into this new era of EHRs and medical malpractice and demonstrating defenses in the courtroom, lots of questions are coming up regarding EHRs. And some of these include the use of cut and paste provisions in EHRs and to what extent they're being used as a substitute for the physician's judgment. For example, I heard the other day a group talking about how a particular visit should always be a level 4 or 5, and we should have some sort of cut and paste that would do that. Well, that certainly doesn't sound good to me. It sounds like the cut and paste is being used as a substitute for good judgment, both from a coding perspective and from a malpractice standard. Password sharing, this raises the whole issue of data security and whether your EHR allows others to look and act like they were the physician when they're documenting things in the record. You can just envision a malpractice plaintiff's lawyer having the physician up on the stand and asking the physician, so how many other people do you give your passwords to? You know, how do I know that this entry is really yours? Is it your next door neighbor's? And then making the doctor look silly or embarrassed in front of the jury. The use of alerts, there's been the term used of alarm fatigue, which I like. Alarms constantly coming up about allergy interactions and other things on the EHR. Physicians being tempted to ignore those or to turn those off or to get rid of those irritating ones because we really don't need to know that. Again, think of this as from the plaintiff malpractice perspective, as in front of a jury, asking the doctors what other sorts of things have they turned off or chosen to disregard. No physician signature in the medical record because the medical record, it really isn't being signed by the physician anymore. We'll get to that in a second about scribes. And of course, printed copies, as Katie alluded to, many EHRs in the printing of the record. The records look unusual. The printout isn't intuitive. Lots of pages being created. Even sometimes we've heard of pages being created that don't show certain parts of the record that you can see electronically, but then don't print out in paper. And of course, what everyone has to kind of remember is that what this medical record is in litigation is a very important legal document that will form the basis upon which a jury may consider whether malpractice has occurred. So how it looks, how it feels, how it's presented in the courtroom is all going to become very important. And of course, corrections. Who can make corrections? How are those corrections made? Is another thing that will come up in a malpractice case. Lastly, and I didn't put this as a bullet, but it's worthy to put down as a bullet, and that is to what extent under your particular state law will there be a physician-patient privilege when a scribe is in the room? If the scribe is simply just taking dictation from the physician, the argument should be that it's no different than using a transcription service. There's no loss of the privilege because a physician is using a transcription service. But if a scribe is in the room with the patient and the scribe is taking down what the patient says and the patient starts to be talking to things knowing the scribe is in the room, has somehow the physician-patient privilege been breached by the fact that the scribe is there? And can the scribe now be deposed and asked about what the patient said or thought or looked or appeared? That's a whole issue that I don't think has made its way through the court system yet and will certainly be looking at in the years to come. Next topic I wanted to talk about a bit was the use of medical scribes. Certainly the use of medical scribes is becoming increasingly popular. There was an article in the Minneapolis Star-Tribune last fall that was talking about how by the end of 2014 there would be 20,000 scribes across the country, and that by 2020 there'd be 100,000 scribes in use across the country. They're being used now by hospitalists, dermatologists, ophthalmologists, all sorts of different specialties, and primary care practitioners. And of course the reason is that it makes it easier for the doctor to spend time with the patient. It gets their face away from the computer screen, gets them back in front of the patient. Good for the patient, good for the doctor. The relative cost to bring in a scribe service isn't terribly great. And so it makes the physicians more productive, makes everybody happy, and ends up being an economically viable model. So certainly scribes are a popular thing and are going to become increasingly popular. Common uses with scribes are things like they assemble patient information about the surgeries, diagnostic tests, medications. They may prepare a summary for the physician to review. Some situations with EHRs, the scribe might open the chart so when the physician comes into the room with the patient, the screen is already open and available for review. And in some practices then, when the chart is closed, who exactly is closing that chart? Is it the physician? Is it the scribe? Those sorts of issues are coming up as these scribe practices become more common. Patient privacy and HIPAA. The Joint Commission has some requirements about scribes. If your hospital is a Joint Commission hospital, I'll just mention that in 2011 the Joint Commission came out with some guidelines about the role and use of scribes for those hospitals that are Joint Commission surveyed, and requiring that the role and signature of the scribe be clearly identifiable and distinguishable from the physician signature in the medical record, and CMS requirements. So with regard to CMS requirements, as you try to dig down and find what the law says about this sort of thing, you find that in the conditions of participation for hospitals, that condition requires that all patient medical record entries must be legible, complete, dated, timed, and authenticated in writing or electronic form, and this is the key, by the person responsible for providing or evaluating the service provided, consistent with hospital policies and procedures. That is not being authenticated by the scribe. That should be authenticated by the physician. The physician or other person, provider, is the person responsible for providing or evaluating the service provided, not the scribe. And there's similar requirements in terms of the physician or the provider authenticating the record for things like hospice and home health. When we turn then to a clinic, a Medicare Part B clinic situation, we won't find conditions of participation there, but we'll find the requirement of having written signatures through a variety of approaches. We start first with the Social Security Act that says that services have to be reasonable and necessary. We then move to the program manuals where CMS can request the records for the purpose of reviewing claims, and then we get to the signature requirements that Medicare has issued in terms of having written signatures. Some of that guidance now is coming out from some of the carriers with examples of acceptable electronic signatures. For example, electronically signed by, and then the physician's name, released by with a physician's name. This is an electronically verified report by John Smith, MD, authenticated by John Smith, MD, closed by the provider's name. So examples of how with EHR the electronic signature can be met. But as you look at those sorts of things, and then you ask about the use of the medical scribe in your practice, the question then comes up about, well, who exactly is signing the record electronically? Is that the medical scribe or is that the physician? And how does your system properly reflect that it is the physician who is signing the record? Records that are dictated and or transcribed but do not include valid signatures, finalizing and approving the documents will result in the denial of claims. So in one carrier's words, we want to be sure that we have a valid electronic signature or we're not going to pay the claim. Additionally, what a carrier can do is can ask the physician that submitted the claim to submit an attestation statement. The attestation statement is going to require that the physician attest that the physician was the author of the entry in the electronic record. If the electronic record isn't reflecting that the physician signed that record, you then get into the issue of whether that was really a proper attestation. And these attestation statements, CMS has said, may not be signed by someone other than the author of the medical record entry in question. And even in cases where two individuals are in the same group, one shouldn't be signing for the other. So again, applying some of these guidelines to scribes is kind of the new emerging issue to see whether or not these requirements can continue to be met. Some of the issues that we've heard about with medical scribes are things like who can open the patient record. If you want the scribe to have the record available when the doctor comes into the room, is the doctor giving his or her password to the scribe and then the scribe then opens that under the doctor's password? Not probably the best practice to be using. It would be much better if the scribe had their own ID and their own ability to open the record so that that could be tracked to identify the fact that it was opened by the scribe. The physician then dictates the encounter to the scribe, and the scribe enters it into the record. Can we see from the record that that was being entered by the scribe? Does it say entered by Jim Platt, scribe for Dr. Jones on this date? And at the close of the encounter, this is getting back to the written signature requirement, does a physician review it and electronically sign it? Or does a physician in your practice just say to the scribe, why don't you close that thing and we're good to go? That wouldn't be the best practice because the scribe is either closing it using the doctor's password, but the doctor never really looked at it, or the scribe is closing it using the scribe's password. Other pitfalls to consider: who can make minor corrections to your EHR? Does your EHR provide a trail to show who's doing that? Do you allow others to close the encounter for a doctor who's absent on a vacation? You know, we need to get these bills out. Doctor's gone. You know, can we just close it without the doctor being there? Again, not a great practice. I'd rather have the doctor close those with his own electronic signature. What about corrections? What about the billing office saying, oh gosh, you know, we don't have something here that's documented sufficiently to support a level whatever visit? Can the billing office make those corrections, or can they just view the chart only? I'm a fan of view only. I'd like to see the doctor making their own corrections rather than the billing office. And then communicating with patients on patient portals. Can your scribe do that? Is that something that you're allowing the scribes to monitor, or is that something that only the physician can do or some other authorized agent can do on behalf of the physician? Lastly, with scribes, if the scribe has got a question or an issue, you know, are the scribes going to use your secure email, or are they going to be doing that through another non-secure email source? All of this points to probably a good idea of having a medical scribe policy, the policy that would talk about who can serve as a scribe, the training the scribes should have, patient privacy, use of passwords, what does the scribe do, what does the scribe sign, what does the physician sign. All of those probably make sense, and probably the scribe should sign that they've received a copy of the policy, agree to abide by the practices, HIPAA and privacy standards. Lastly, with medical scribes, you need to make the business decision whether you're going to employ your own or contract with others. If you contract with others, as in all of these contracts, you know, take a look at those things to see about indemnification clauses and who has to pay what if something goes wrong. So with that, I'll turn it over to Breyer.
Thank you, Jim. And I am going to talk about selecting a vendor for your EHR contract and EHR contracts in general. Also, we'll talk a bit more about passwords, a little bit about patient portals. So if the question that you have is not addressed in those topics, please feel free to send in your questions. Again, it's the bottom right-hand corner of your screen, and we will get those in real time. So EHRs obviously are the wave of the future, and selecting a vendor is one of the important things you need to think about. It's very easy to get locked into a long-term deal, and unfortunately easy to get into a long-term deal with a company that's not providing you with what you need. So it doesn't matter how good of a contract you have if your vendor is not the right person for you. A good contract can help you, but it's not going to save you if the vendor is no good. So try and get references from other entities that are kind of in your same type of situation. Talk to them about how well the software and the system fits with their organization. Ask to see a demonstration if you can from the vendor. If they're not willing to do that, that might be a red flag right there. Consider having a selection committee with users that will be actually using the system, your physicians, your nurses, your billing staff. Have your IT department involved, possibly an IT consultant if you don't have an IT department. Have administration there so that they can see how things are working as well. And figure out, you know, what are the functionalities that you need? What fits with your organization? What do you need this system to accomplish? And make sure that that can actually happen with the vendor that you're choosing. As far as technical requirements, think about the ability of this vendor's system to interface with your own system, with your practice management that you have, with other software systems, the technical functionalities that would fulfill regulatory requirements, meaningful use being a big one. Think about whether the vendor has ever had to put this system in place with the systems that you already have. Can they do the transition appropriately? Can they make the systems talk to each other? Katie had talked about interoperability by 2017, and I think some of our clients would be pretty excited to have their systems talk to each other by 2017, just internally. Also think about the pricing. This is obviously a huge part of the issue, but don't just look at the final number that they give you. Think about the pricing model, upfront costs versus a monthly subscription, training costs, travel costs, implementation and conversion, any cost to update your existing systems. Would you have to get a new version of Microsoft software? Would you have to buy new servers or workstations? Those are sometimes hidden costs that don't show up but are requirements of the system to work. Oops, I'm going to go back. There is also the cloud versus installed software issue. The traditional way that the EHR would work would be the software would be installed on your own servers, and all data would be held by you on your own machines at your location, whether on-site or off-site, and the updates would be done by you. In the cloud or software as a service or subscription ASP sort of system, that is hosted and managed by the service provider at their central facility, often with a bunch of other end user clients who are like you. And the client just accesses the software through a web browser. That is generally cheaper and can be very cost effective, but then all of your data is being held and managed offsite by somebody else. So there are some concerns there, and we'll get to some of the security issues. But generally, it's a good idea to try and put together a vendor questionnaire about how the vendor is going to be accessing your information, your PHI. Ask about their security policies, their own physical security, their backup and disaster recovery, where are they going to store the data, is your stuff going to be separate from other customers, if there's a breach for another customer, is that going to affect you, have they had data breaches in the past, and what were the circumstances? And the answers to those questions will hopefully help you. And maybe it will help the vendor figure out what they need to do. All of these vendors will be your business associates, and so they should, under the terms of a business associate agreement and under the terms of HIPAA as applied to business associates, they should be having all of these things. They should have all of this stuff in place, but you want to make them aware that you are thinking about that stuff too. Consider a bidding process or an RFP process and select at least a couple finalists so you can measure them against each other and make sure you're getting what you need. So what should be in your EHR contract? Generally, the elements that you will see, the quote with the proposal for pricing and modules and the schedule. You'll have a software license or service terms and conditions, maintenance and support terms and conditions, a statement of work or SOW that outlines implementation, conversion, customizations, training, all the other stuff that they're actually going to do. Often a service level agreement, and hopefully always a business associate agreement. In that quote, get the pricing in general, get the name of the software and the modules that they're going to provide, the type of implementation and conversion services they're going to provide. If they're giving you a discount, you'll probably want that reflected there. And again, make sure that it tells you what the minimum hardware and software standards are for your system, so you can check and make sure you have those so that there are not these hidden costs. Sometimes they'll just say in the agreement somewhere that the client will agree to have the minimum necessary things in place as told to you by the vendor. And you should get that in writing so you know ahead of time what those are, so that you know what you have to buy, if anything. So on the front end, again, define that product or the software. Figure out what exactly it is that you're buying. Sometimes they make functionality promises in the sales process, and that should be reflected in the agreement. If they tell you it's going to do a certain thing for you or does some magic billing issue that you really need, make sure that the agreement says that they're going to provide that magic to you too. Pretty much if you've relied on something provided by the vendor in making your decision about which software to purchase or which system to purchase, get that included as part of the contract. So the documentation, which is often a defined term in the contract, see what that includes. Sometimes it's exhibits, sometimes handbooks, manuals, sometimes other materials. And that other materials can be key if you can include in there all the stuff that they provided to you, including presentations that they gave you and the other glitzy promises that they've made. So get the specifics about what they're going to do and what they're going to promise. Warranties are another big part of the contracting process. You want the system to perform according to the documentation, and you want them to warrant that it will. You want them to warrant that they're going to comply with all applicable laws and regulations, that their intellectual property is not going to infringe on anybody else's intellectual property, and if it does, how they're going to fix that. The worst thing would be to have a system that some third party says, oh, no, that's our system, and you can't use that, and in fact, we are shutting the whole thing down. Make them warrant that the services they're going to provide will be in a professional and workmanlike manner. Industry standard is a good thing to have in there. And say that the vendor will work diligently with your third-party database vendors, because there are bound to be other parties involved in that. For payment issues, you want to tie any upfront payments to certain milestones and hold a portion of the payment that you're going to owe until after the go-live date. The vendors generally want as much money as possible at the beginning, and so you want to try and backload that to the extent you can to make sure that things are working out. Annual or monthly fees, make those start on the go-live date, not on the contract signing or a certain number of days after the contract signing. If there are delays in implementation, you don't want to have to be paying for those fees until you can actually use the product and until it's working as it should. It's a good idea to try and get a cap on the annual increases to maintenance fees or subscription fees. Pay attention to how monthly fees are calculated or how user fees are calculated. What does the term user mean, and are you going to get penalized if you hire 5 new providers? If you have an uptick in transactions, or is there a minimum transaction amount that you're going to be on the hook for even if your transaction numbers are lower? And ask about future pricing for additional users or new locations or new modules, particularly if you anticipate in the next 1 to 5 years that you're going to be going somewhere else, merging, anything like that. And of course, if it's not working, what can you do? How do you get out, and what are you going to be on the hook for? Termination, you want to pay careful attention to that provision of the contract. Generally, providers will want to be able to get out faster, but they don't want the vendor pulling the carpet out from under them. So the termination can be a tricky issue. I don't like termination clauses that don't allow for any kind of without cause termination, but vendors try and hold real tight onto their you may not terminate unless we totally screw the whole thing up. So that's one that's worth fighting about. Security and business associate agreement issues, also in my opinion, worth fighting about, because those can cause huge, huge problems for you. Related to that is indemnification and limits on liability provisions in that contract. Make them mutual so that you have a limit on your liability, not just the vendor, and make them indemnify you for problems that they cause. The vendors don't like to do that. They don't like to have an indemnification for anything, but you really do need that, and particularly when there are security breaches or complete failures of the system that result in costs, you want to be able to have the vendor be on the hook for that. Support and maintenance, you want to make sure that that is described well. It could be on a standalone document, or it could be included in the main terms and conditions. Make sure you get updates, make sure they are providing the services that they are supposed to provide in the times that they're supposed to provide. One issue that we see a lot is the amount of uptime. So the system uptime and response time, it's great if you can have a provision in that agreement that will say the system will be working 99.7, 99.9% of the time other than planned downtime. Which hopefully is not during key hours of operation. And you want them to say when they're going to respond to issues. And usually there will be kind of a stair-step approach to that. If it's a critical issue, you want a response from them in 15 minutes, and you want them to solve it in 2 hours. If it's not critical, then those timelines can be expanded, but you want to make sure that they're paying attention to you. So let's say you've already signed the contract and you're having horrible issues. Which is not at all uncommon, including with giant vendors that you would expect to have things under control. So often they don't. So document those issues and problems that you're having. It's great if you can have an email trail showing what you've tried to do to fix things, how reasonable you have been in demanding these fixes, the fact that you told them that there are critical issues that are causing you problems. It's good to have that email trail. If it's phone calls that you're making, document those phone calls, the dates that you made them, who you talked to, what they promised you. Have a trail. So if there hasn't been a breach, it doesn't mean, or if there hasn't been a breach because maybe the agreement doesn't have a lot of provisions that explain exactly what they're going to do or describe breaches, it doesn't mean that you don't have options. You may be able to terminate, you may be able to negotiate a termination, even if the agreement doesn't provide for one. But you also might be able to get some discounts. You might be able to get upgrades for free. You might be able to get them to promise better support and to do that in writing so that you do have a contractual provision then. You do have options. So the best thing you can do is pay attention to what they have and haven't done, document it, and communicate that with them. One thing that you don't want is for them to be able to hold your records hostage. So in the agreement, it's very helpful to have transition language that talks about how they will help you transition to a new system, and at worst, something that says they will use reasonable efforts to get this system going with another vendor. Some protection might be offered there by the business associate agreement, which will require the vendor to basically to provide access, and so you might be able to hang your hat on that, but best to have something specific about those transitions. So switching a little bit to some other general medical record issues, one question that we get quite a bit is who owns the information in a shared system? And I don't think Katie and Jim can weigh in on this if they want to, but there's not really a specific answer to that question. It really depends. Basically, you want a provider to be able to get and keep the information that relates to their patients, but how that works out is kind of a case-by-case basis. How is ownership going to be tracked? Again, that's when you're sharing an EHR with another. Often a hospital will share it with a clinic, and how can records be taken out of there? Generally, the main system will keep all the records, and copies would go to anybody that's leaving the system. Which party in a shared system is responsible for making disclosures in the event that there has been a breach or complying with requests for access to information? Again, this is often a case-by-case situation, but if there has been, for example, an employee at a clinic peeks into the hospital's records without any authorization to do that, I would suggest that the hospital should work with the clinic, and when they're notifying patients about this, sending a joint letter is often the best way to do that. Who reports it to the Office for Civil Rights as a breach? I would say probably it is the entity that owns the EHR, but there is, that is not set in stone either. So that's something to work out between the two parties. Moving on to passwords. Jim talked about passwords a little bit. Thought I would just show you the slide with the worst passwords of 2014 as put together by Splash Data. If you have any of these passwords, you should change them to something better. I was curious about number 20, which is Michael, which seems to me to indicate that people named Michael don't do the best job with passwords. Sharing passwords, as Jim said, generally a bad idea to do that. One thing to think about is making sure that your processes at your hospital or your clinic don't essentially require the sharing of passwords. We had a question come up with a physician who got in trouble for sharing a password, but the reason that he had done it was because the hospital system had its operating room screens time out after a certain period of time, so the images that the physician needed to do the surgery went blank, and if he had taken the time out to type in his own password, it would have created obviously major patient care problems. So he would say it out loud in the operating room, and then everybody would hear it, and that's a problem. So while sharing is generally a bad idea, make sure that whatever process you have doesn't have a negative effect on patient care. Changing passwords, generally a good idea. Your system should require it every so often. Other password issues, Katie talked a bit about surveyor access and what kind of passwords you give to surveyors. If there are vendors, if there are payers who want to set up a kiosk, consider whether they really need access. I would not give them somebody else's password. I would suggest they get their own passwords, and hopefully, again, have only read-only access in those cases. Figure out, too, do they really need that access? Is it something that could just be printed out for them so that they can see? Could they just look over somebody's shoulder as somebody else has gone in and have that documented? Figure out if there are other ways to do it. A word on patient portals, and Katie is going to step in for this.
So I just wanted to mention, so patient portals are becoming more common, probably mostly because of meaningful use payments that are conditioned on having one. Just to pull some data for all of you, this very scientific study by Healthcare IT News said that patient online access to EHR went up by doubled in 2014. And the main things that patients want to be able to do, according to this study, are listed here on the slide. But in particular, overwhelmingly, patients want to be able to see the third bullet, to see the doctor's notes and their test results on the patient portal, and also schedule appointments. Those are the two sort of popular things that they want to be able to see. A couple sort of general comments, and then I'll let Briar address the really sticky issue of minors in portals. Remember that having a patient portal doesn't replace your duty under HIPAA to provide access to a patient to their entire designated record set that you as a covered entity are required to keep. I've seen, I guess, at least one client who thought, well, now we have patient portal, and so we can kind of do away with our function where someone can ask for their record and paper, and we provide it that way. It doesn't replace your duties under HIPAA, and largely because what's on your patient portal isn't necessarily the entire set of information that a patient gets when they ask for it under HIPAA. So, and you may want to limit what's in the patient portal to only what you have to have for meaningful use or other reasons. The question we often get is, can your portal include access to records that other healthcare providers have given to the organization that's holding the portal? There's not a restriction, as we said before, on providing information from other providers to the patient, unless, of course, you're talking about really special information that's protected by, for chemical abuse and dependency programs that are protected by stricter federal laws. So there's, again, not a restriction on, once it's information that the covered entity has received, that you can't pass it on unless it's protected otherwise.
And speaking of that, so parental access to minors' healthcare records. Generally, parents, of course, have access to the records of their children, but I believe it is every state has an exception there for minors who are seeking access or seeking care related to generally pregnancy, alcohol and drugs, and sexually transmitted diseases or other sexual issues. States say that minors have the right to that information and the parents don't have access to that unless the minor gives them access. So if a minor has a patient portal and the parent generally has access to it, the parent has the password, the parent can get access to information, which again you would generally want for a parent with a minor. What do you do then when the 15-year-old comes in for her pregnancy test and those results go into the patient portal? There are no very easy answers to this, I think, and I don't think there are very many that have come up with a perfectly clean way to do it. But one option is to set some age limits for parental access, and parents above a certain age. I've seen the suggestion of age 14 or anybody within 30 days of their 14th birthday. Those patients get their own passwords. That works a little bit, I think, but I can certainly see a parent saying, okay, well, give me your password because I need that information to fill out your school forms. The 15-year-old gives that information without a second thought, and then 2 years down the road, they're 17 and they are going in for some alcohol treatment or something else that is protected, and they have forgotten that they gave their parent the password, or they all of a sudden want to change their password, and then the parent is upset and demanding to know why. That's something to discuss with your X-year-old patient, if you've set an age limit like that. Discuss with them so that they're aware of the confidentiality issues there, and that if they change their password, their parent is probably going to ask about it. Another option is to not put any of the restricted information on the portal. And that generally works. Katie pointed out that meaningful use does require you to have certain things in the patient portal, available in the patient portal, but there is an exception that essentially says that state law that would restrict that information for privacy purposes overrules those meaningful use requirements. So you could say, we're not going to put any patient minor information related to those things, any of those protected areas, onto the patient portal. And that is okay, but then think about if there's anything else that you would need to restrict. So if it's part of some physician notes and what you're restricting is lab results, but the physician has noted something in their progress notes, you want to not include that in the patient portal either. So it's something that providers need to pay attention to, and the best thing to do is have appropriate communication with your minor patients that kind of sets their expectations and puts them in control of that information to the extent you can. One other last thing here, Jim talked a bit about how you can have people sign off, or when you should, if ever, have people sign off other than the provider who did the service. We have seen some problems with providers never closing their charts. They are fired, or they otherwise leave. They're not around. They refuse to do it. There's some question about whether that needs to be reported to the National Practitioner Data Bank. The NPDB has said they expect the report of anything that would negatively affect patient care, essentially, and that sometimes a failure to complete charts can do that. It has the potential to adversely affect a patient's health or welfare. So it may require a report to the NPDB. That may, for some physicians and other providers, be enough to get them to complete the charts, but not always. So if it doesn't happen, then I would consider having somebody else complete the chart or close the chart, but have that audit trail, have it very evident in the record that it was provider Y who completed provider X's chart, and you can note the reasons in your own internal charts as well, but make it clear that it was somebody else, not the originating provider, who did it. And I think that's all I've got. We may have a couple of questions to go for.
Yes, you can send us your questions there by going to the bottom of the screen and adding those in. I've got a couple, and then we'll turn back to Katie. Question about having the EHR having a sign-all for the provider, which means they do not actually review the documentation. Also, documents signed off that have blanks in the documentation. Question is, does this create a legal risk? Yeah, I think it does. I think a sign-all is like a rubber stamp with the old written records. You know, the rubber stamps don't work. So, you know, you need to have the provider electronically sign that they've reviewed the documentation and that they've authenticated it. And in terms of having blanks, again, always think about the written record. You know, if you had a written medical record and it has a bunch of blanks in it, does that look bad? Yes. If there was a risk management issue that arose, does that look bad? Yes. Does it look bad if the patient requested their records? Yes. So having blanks in the records, electronically or otherwise, is not a good practice. The second question I got was a question about, can a scribe who may have a coding background prompt a physician to add greater specificity to a statement or diagnosis he makes? This raises, you know, not just legal issues, but kind of HR issues and coding issues. But sure, I mean, if I were at a health system, and a scribe had a concern about a physician adding greater detail, there's got to be some process or some provision in your policy that would address that. I don't know if the scribe should mention it to the physician. It seems like a good idea to me, but it seems like it needs to go someplace else too, because chances are that that physician is probably not doing that in a lot of different situations. So there needs to be some ability for the scribe to get to other people who can then work with that doctor to bring the documentation up to snuff. Other questions?
Yeah, so we have one question about chronic care management and how are we supposed to use electronic health record systems for the chronic care management service. So most of you probably know that there's a new service, not necessarily a benefit category, but there's a new service Medicare will pay for chronic care management, and it is, in order to get paid for that, you have to use electronic health records pretty intensively. There is, in the final rule for the 2015 fee schedule, there was a very handy-dandy chart that went through all the elements of chronic care management and then which ones you had to use EHR for. And so I would definitely refer to that. But it basically involves any communications that the primary care, or I guess the providers providing chronic care management services has with other treating practitioners of the patient when they're managing these chronic care conditions, has to be made via electronic health record systems or electronically somehow. The recording of all of the information about the patient's chronic care management has to be captured in an EHR. It has to be a certified EHR. And you also have to provide the patient with an electronic copy or ability to access their care plan electronically. And I think maybe most importantly, in your consent, where you ask the patient, do you want to receive chronic care management services, that you have to have. You have to have this consent in order to bill. You have to get the patient's written agreement that you can access and send their information electronically. So that is definitely something to remember when you're developing those consent forms.
Another question about the restriction of confidential information and the age that I mentioned of 14, and a question about whether I know what the age threshold is for Minnesota. And generally, the 14 is a bit of a made-up number. I think that is kind of a consensus about what an appropriate, when a person can start reasonably making those determinations. Minnesota doesn't have any special provision that says what age is. It just says minor, so basically under the age of 18. But there is in Minnesota and in many other states an exception for information can be released to a parent if it is necessary for, in the provider's judgment, for the health of the patient. And so, when a 9-year-old comes in for STD testing, that's a situation where I would want the providers to notify a parent or someone else to deal with that issue. But, otherwise, it's kind of up to the provider. Related to that a little bit, can a minor consent to their own portal account if that account has behavioral health? I would say yes. There may be some state law issues to think about depending on where you are, but generally, yes, behavioral health records would be protected to the same extent that others would be.
So we've run over a bit, so thank you for listening, and join us next March, on March 11th, for our next webinar about ancillaries.